That is enough about the courts. And now I think it's time for some action. Yeah, it's been all talk. Time for some action. We will look at a claim and then a defense and counterclaim. Now, in a dispute, there are some usual steps, and I think they're pretty much the same in your countries. You start off, there is a dispute between two parties. Has it been resolved? No. So we still have a dispute. Now, one party will instruct his lawyers to send a letter before action. And then if that is not successful, if that does not produce the desired result, he will instruct his lawyer to issue a claim form. Well, actually, he will instruct his lawyer to have a claim form issued by the court. Who serves the claim form? Who serves the claim form? I think this can vary from legal system to legal system. Sometimes the party to the litigation is responsible for serving the claim form, and sometimes an officer of the court does it. Sometimes I think you have a choice. So that is a sample of a letter before action. Dear sirs, we understand from our clients ABC Limited that they have supplied you with goods to the value of £100,000. This is evidenced by 1, your receipt for the goods, and 2, their invoice dated 5 weeks ago, which you have not yet paid. ABC Limited have instructed us to commence proceedings against you to recover the amount you owe them unless they receive payment in full within 14 days. Now, that is a sample of a letter before action. And again, I think it'll probably be familiar to you. It's the sort of letter I imagine you write at the first stage of a dispute. Pay my client or we sue you. Yeah, that's what it says in simple terms. Now, I use the word, we will commence proceedings. And I've also used the word procedure this morning. I don't think I've used process, but these are 3 words which look alike but are different. Proceedings, it's usually plural, and settling a legal matter in court, unless you're talking of arbitration. Our client has instructed us to commence proceedings unless the outstanding amount is paid in 14 days. In simple language, that means to start a lawsuit, to sue you. To commence proceedings. Procedure, the rules you have to follow in court proceedings. So, the rules of civil procedure set out how proceedings in civil courts are run. And then process is a series of actions that are done in order to achieve a particular result. For example, and there are examples there, the use of the word process. The aging process, becoming a lawyer, is a long process. And as I mentioned yesterday, you can avoid the process of setting up a company from scratch by using a shelf company. Now, I might have to tell you about something called the Wolf Report. Wolf LJ, Lord Justice Wolf, one of our senior judges, he produced a report in 1996, as a result of which a number of changes were made to the civil procedure rules. And in particular, I'll start by pointing out some changes to terminology. You may know the word writ. Writ. As a result of the Wolf Report, we don't call them writs any longer. We call them claim forms, and that indeed is what we're going to look at very shortly. A claim form used to be called a writ. And the person who is the claimant used to be called the plaintiff. We used to have something called further and better particulars, is a request. It's now called a request for further information, which is a more accurate description of what it is. We used to have something called an affidavit, a sworn statement. That's now called a witness statement. So the witness Witness can give evidence in person, in court, or by means of a witness statement, which is a sworn statement saying, I swear by Almighty God that the contents of my statements are true. On this day, this happened. Da, 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 da. There's also something called discovery. It used to be called discovery. We now call it disclosure. And I'll come to that in a minute. So you've got, on the left side, you've got the old terminology, then you've got the new terminology. You still need to know the old terminology because it's still used in some jurisdictions. And of course, you come across some pre-Wolf writing. There was also, as a result of the Wolf report, a change, I think, in attitude. And he introduced what are called pre-action protocols. We'll have a quick look at one shortly. Issuing a writ or issuing a claim form used to be very quick, very easy, very cheap. So people would issue a claim form and then think about it. And then they would use it as a sort of technique, as a tactic in negotiations. Right, here's the writ, I've issued it. It costs £10 or something. But Wolf said, no, that's wrong. People should only start litigation after having done some work and worked out the strengths and weaknesses of their case and decide that they really want to do it, and having tried to settle. He also introduced something called conditional fee agreements, under which the client has to pay a smaller fee if the lawyer is if he's unsuccessful. If he's successful, he pays a higher fee. That's called a conditional fee agreement. So this has been in place now for 12, 13, 14 years. And I think on the whole, people regard the Wolf changes as having been good. But there are also, as is often the case, there are still problems with the system. And indeed, 2 years ago, we had another big report called the Jackson Report. And there are changes being implemented now as a result of the Jackson Report. What these changes are is probably, it's too big a topic for today, so I'm not going to discuss it in any length. If you're really interested, look it up on the internet. But it's mainly to do with costs and what a successful claimant can recover from the other side. So I said cost, and you may have heard costs as well. Cost and costs. You may have seen cost of litigation and litigation costs, the S at the end. Now, they're different. The cost of litigation is the overall cost. And that's not just legal fees. That's things like, if it's a company, the time in working on the case. Possible damage to reputation. So I would call that, include those in the cost of litigation, as well as litigation costs, which to me means the legal fees and the court fees. And the above is because of something Sarah mentioned to you yesterday. She brought to your attention the difference, which you all know, between countable and uncountable nouns. Cost can be used in a countable and an uncountable way. And this is, it's for that reason that you have this distinction between the cost of litigation and litigation costs. It's a pretty subtle point. Yeah, lots of English people won't really understand it, but as a lawyer, it's worth you understanding it. As I said, we're going to look at the claim form very soon. But before we do that, I've got a question for you. I imagine that some of you in your careers will have had experience of, that you will know something about the common law litigation system. So I'm going to ask you what things about civil litigation in common law jurisdictions surprise you. I don't know.
Very different from Italy.
It's very different. Okay.
All of it's surprising.
It's just all surprising. Good. How
Our
exciting.
civil proceedings are much longer,
Yeah.
and they are private, not public.
Okay. Okay.
We are all private.
Okay. Thanks. Any other points?
You promote ADR, alternative dispute
Do we promote it? Yeah.
we are not much popular conciliation, mediation.
Yeah, you think it's more popular in our system than in the UK? Okay, so you're saying it's more popular in the UK? Yeah. Okay. Okay. Any other points? Yes. Yeah. That's okay. Okay. Now I tell you, I've had this discussion a number of times, and some of the points you mention come up, but also a lot of people say that in our system we have a lot more oral argument and evidence. Your litigation is a lot more document-based. Ours is based more on oral evidence given by witnesses in court. And they are witnesses who give the evidence, and they are also cross-examined by the other side. So the other side's lawyer can ask them questions. This whole concept of disclosure or discovery in the US, each party has to disclose to the other all documents relevant to the dispute, those which help its case and those which don't help its case. You have to put your cards on the table. That's an English saying from gambling. You have to put your cards on the table. You have to show the other side what you've got, the strengths and weaknesses of your case. And the thinking behind this is that once both sides realize the strengths and weaknesses of their respective cases, they will be more likely to settle. And you think, oh, well, as a lawyer, you pretend you haven't seen some document that's damaging to your client. You can't do that really, because a lawyer has a duty to the court. If he does, if a lawyer does do that, and he ignores a document deliberately or tells the client to tear it up, and he's found out, he will immediately be disqualified from acting, disbarred. It includes documents in electronic form. So these days, that can be a huge exercise. When this started, producing a document, producing a letter was a task. Yeah, it wasn't easy. I remember, when I started, there were no PCs. I dictated a letter to my secretary. She would type it out. I would check it. Long process. Now it's become much, much easier to produce words, documents, letters, and so the exercise, the discovery exercise, has grown. It excludes one thing. It does exclude is privileged documents. Now we have something called legal professional privilege in this country, and I think you have something similar, but it's different. Our legal professional privilege protects all communications between a lawyer and his or her client from being disclosed without the permission of the client. And so the privilege is that of the client and not of the lawyer. The client receives the advice from the lawyer, and then the client decides, I want to keep it secret, or, okay, I will show you this. That's the client's decision. Whereas I think that in civil law systems, you as lawyers have a duty of confidentiality, which is slightly different. Yeah? Now, other unusual things, you tell me. You have told me some things, so thank you. But I'll just finish with one point which occurred to me. I was working in Italy with some lawyers who had worked on cases involving Parmalat, the big fraud. Yeah? And what I found strange is that the same court was dealing with both the civil proceedings and the criminal case against the executive whom it was alleged had committed fraud. Yeah? I found that very strange. We'd never get that here. We'd never do that here. There'd be separate proceedings.
You need always two separate processes.
Yeah. And I can see the benefits of doing it in your system. Yeah. I can see the benefits. Okay. Enough talk. Action, as I said. Here you have a claim form. Please just have a quick look at it. Okay, let's read it out aloud. Yeah? So, it's in the High Court of Justice, the Queen's Bench Division, the Royal Court of Justice, over there. It's a claim form. The claimant is Counter and Bean, a firm, and the defendant is Millennium Solutions Limited. It's quite an old claim. It's about 10 years old. Right, I've done enough talking. Can one of you help me? Please read out the brief details of claim. Yeah? One of you read for me? Yes? Sir? Yes, please.
The claim is for damages for breach of a written contract dated 23rd November 1998 between the claimant and the defendant. Software supplied by the defendant under the contract contained the computer virus which substantially corrupted and disabled the claimant's office network.
Okay, thank you. Breach, and virus. And the claimant expects to recover more than £50,000, which is why he is not in the county court, he's in the Queen's Bench Division. So the older ones amongst you will remember this. Yeah? In 1998, 1999, there was, I think, a huge bit of marketing by the computer industry. And they said, at midnight on the 31st of December, 1999, unless you buy this very expensive piece of software, your computer is going to explode. Do you remember that? Yeah, yeah. The year 2000, the millennium bug. Yeah, okay. So, let's turn over the page and let's go through the particulars of claim. Right, can one of you please read the particulars of claim for me, please? Yes, please, yeah.
The claimant is a two-partner provincial firm of chartered accountants. The defendant is a member of a multinational group of computer companies specializing in the supply of millennium compliant software.
Thank you. Next, number 2. Yes, please.
By a written agreement dated 23rd November 1998, the contract, the claimant purchased from the defendant's subsidiary the goods containing a software program named Backshield 2000. This program is designed to protect computers against the problem of data non-recognition associated with the advent of the year 2000.
Thank you. Sir, you? Yes.
Under Section 14 of the Sale of Goods Act 1979, the following terms were implied by law into the contract. That the goods were of satisfactory quality and that the goods were reasonably fit for their intended purpose.
Okay, carry on. Yeah. Please, carry on. Yeah, you. No, the same gentleman. Yeah.
On 17th January 1999, the defendant supplied the goods to the claimant. However, in breach of the contract, the goods contained a computer virus which, following installation, immediately erased all of the claimant's internal account records and posted mail or grocery of offensive nature to every person listed on the claimant's client contacts database.
Wow, that's serious, eh?
Yeah.
Very serious. Oh. Okay. Will somebody read number 5 for me? Sir, yes, please.
As a direct result of the introduction of the virus into the claimant's computer network, most of the claimant's clients have withdrawn from all existing and future work with the firm. And the destruction of the firm's accounting records severely restricts its ability to quantify or recover the majority of its outstanding fees. Full particulars of loss and damage will follow in due course. However, without prejudice to such particulars, as at today's date the claimant's best estimate of its financial losses sustained as a result of the defendant's breach of contract is not less than £1 million.
Okay. And the, continue, just finish it. And the claimant's claims?
And the claimant claims, one, damages for breach of contract, interest pursuant to S.35A of the Supreme Court Act 1981 at such rate and for such period as the court thinks fit, and the costs.
Okay, thanks. We just say Section 35A. That's how we would, yes, okay. Thank you very much. So, there is the claim.